Hey guys, this is Lauren. This week I've got Richardson versus Corvallis Public School District. This case was heard by the Supreme Court of Montana, submitted on April 24th, 1997, and decided on December 27th, 1997. The decision was delivered by Justice Nelson. So in this case, Donna Richardson took her son to school. It was snowing outside. There was ice on the ground. She walked him into school, and on her way back to the car, she walked on a snowy patch of ground that she perceived to be a path, but was actually had a grass patch. And she slipped and fell and sustained some injuries to her person. Donna Richardson sued the school. She stated that it was the school's responsibility to either post a sign or maintain the path. She said that there should have been a sign that said there was a lurking danger to warn people that this may be a bumpy and potentially dangerous path. However, the school argued that the path that she had taken was not a normal path, and as a parent of a student that went there, she would know where the paths would be going into the school and know that this was not a normal path. The court decided in Corvallis School District's favor and determined that the school didn't have a duty to maintain that part of the path. The conditions of the snow and ice were apparent to all people, and this law was based on a previous law that stated that if a person knew of the conditions before they tackled these conditions, that it was not the school or the stores or anybody's responsibility to maintain beyond what the normal maintenance of the property would be. And the school did not anticipate that anyone, even Donna, would be injured when she took this path into the school. The two cases that this case was based upon were Lubeck versus Safeway stores and the Sarek case. So in the Lubeck versus Safeway, a woman fell in the Safeway parking lot, which was covered with a natural accumulation of ice and snow, and the courts ruled in Safeway stores' favor because there's no liability because the formation of ice and falling snow are universally known. However, in the Sarek case, they awarded the case in the favor of of Sarek, who's the defendant, or the plaintiff, sorry, and adopted the standard that the property owner has liability in situations where natural accumulation of snow and ice have been altered. In this case, they had moved snow and piled it up in a berm, and this person had climbed over it to try and get to their car because it was the place where they were supposed to cross was blocked, and sustained injuries. And so, in this case, in Richardson's case, the school had not altered the natural accumulation of snow, and Richardson was a normal a person that would have been in this situation where she would have been around the school a lot and would have known that this was not a path, and so the school had no liability, is not liable for her injuries because she should have known that the paths into the school, and the school had been doing just normal maintenance and didn't cause a clear danger to her or any other person.